So first we're going to look at a video that's going to help walk us through this. And this is, let's see here. This is Williams Brandon Dash Joe. Law made fun and simple. One stupid fuck. Okay? So go over and check him out. Let me grab his link here real quick and drop it for everybody. And remember, folks, hit that like, share, and subscribe button. And of course, to help further any other kind of support and love, there's a PayPal link down below. Always appreciated. Every little bit is counted. It counts.
Hello there.
And so we're going to get into this. And this says how to have infinite money. And he's got a 10-minute video here we're going to look at. And he explains it very well. And then after we get done watching this video, I'm going to go through some of these codes so we have some time to look over them and reflect on exactly what the plain language is in these codes. Again, the StreamYard link is down there for anybody that wants to jump on panel.
Brandon, this is my brand, and today I am going to teach you how to have infinite money in less than 10 minutes. Let's get started. So first and foremost, we need to figure out what is money. Well, everyone thinks they know what money is. They think it's those green things in their pocket, but it's definitely not. I'm going to prove it to you and explain the whole thing to you. So let's start off at Article 1, Section 10 of the Constitution. It says, no state shall, and then it says a whole bunch of things, but one of the things it says in here is, make anything but gold and silver coin a tender in payment of debts. Now we look up.
So let's take a look at that in depth as we see Article 1, Section 10 of what he's talking about. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts. A tender in payment of debts. Pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. And as we've been discussing, these people are responsible for assistance. They're not supposed to be interpreting the law. And if you are the bringer of the law, then you should know that law and how to interpret it. And this is why I urge you to get back to concise English. The next one, it says foreign policy by states, coining money by states, legal tender issued by states, state bills of attainder, state ex post facto laws, and then we talk about contracts in 1.6. Overview of contract clause, historical background of contract clause, evolution of contract clause uses, and then state contracts. See, this is where you get involved in the state contract under a private contract with the enumeration at birth, because you had a general journal with a private practice doctor as an OB. That's the prenatal record. Then that private practice doctor, when you went into labor pains, he gave those records, those prenatal records, to the hospital for you. That's part of that private contract with him. You guys need to start understanding that they're telling you how to contract. It's already there. It is full disclosure.
Got money in Black's Law Dictionary, and we've got unusual and ordinary acceptation. It means gold, silver, or paper money used as a circulating medium of exchange. Now, this part is really the most important part, right? And
Because you would think that paper as a medium of exchange would include those Federal Reserve notes.
does not
It does not.
embrace notes, bonds, evidences of debt, or other personal or real estate. Now,
So those are either promissory notes or contracts made to order of payment.
keep in mind on that one, because we're going to be getting into some excitement here now. Now, check it out on here. Federal Reserve note. Wait a second.
Yeah, wait a second. Y'all been using that Federal Reserve note as money, and it's not. 12 USC 1813, if you go back to the videos earlier today, and the definition of deposit, that's the codification, and then it's supported in the Code of Federal Regulations, which regulates and enforces its use. And it says, the unpaid balance of money or its equivalent. And you've been giving Federal Reserve notes and checks and coupons and all kinds of things, and not understanding that those are all obligations and other securities of the United States, which includes all bonds. Includes all bonds. And then it tells you all those different terms that are like wordings with bonds. And in there it says stamps and other representatives of value. And your word is a representative of value, and a man's bound by his word. I urge you once again to comprehend your value as opposed to any other value.
Definition of money says it does not embrace notes. Interesting. Well, if these bad boys ain't money, what in the hell are they? Well, the answer comes from the Uniform Commercial Code, Article 3, Section 104, which we're going to talk about more. And they're actually called negotiable instruments. So instrument basically means like any document or contract or deed or security. Negotiable means transferable. So this is actually a security, essentially, or a promissory note that I can transfer to you, and then you will now be able to possess that value, right? Now, they break down UCC 3, Article 3 is the section that's all about negotiable instruments, all about our money supply that we have. All the information on that can be found in UCC Article 3, which we'll be talking
And Article 9 covers your securities. 9-307, debtor, location of debtor, subsection H. United States is located in Washington, D.C., and it is known as the debtor. Under 18 U.S.C. 8, obligations and other securities of the United States pursuant to 18 U.S.C. 7, special maritime territorial jurisdiction, and 18 U.S.C. 9, vessels of the United States.
talking about a lot. Now, they define negotiable instruments as only two things: an unconditional promise to pay or an unconditional order to pay a fixed amount of money, blah, 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 blah. We're going to be talking a lot about this. This is all how infinite money really works. So we have, like I said there, negotiable instruments, unconditional promise to pay or an unconditional order to pay, right? Now, there's two different terms that you're going to see, and we're going to break all these terms down, right? You can see right here, this is from the Bill of Exchange Act of 1882. There's two different.
So it's not a bill of credit, it's a bill of exchange. Okay? Understand that principle. It is not a bill of credit, it is a bill of exchange.
Different terms. Bill means bill of exchange, and note means promissory note, right? So the unconditional order to pay is a bill. You get bills in the mail. We're going to cover that in just a second. That's an unconditional order to pay, and then you have the unconditional promise to pay. So here's just a random bill. We've got down here, it's an unconditional order to pay. It says billing date. What is bill a shortening for? It's a shortening for bill of exchange. What is a bill of exchange? It's a negotiable instrument. What is a Federal Reserve note? It's also a negotiable instrument. You're starting to see where we're going with this? Now, this is truly effective.
I love this guy already. Because he makes a perfectly good point. Do you see where we're going? Like I've said before, everything, in fact, is some type of negotiable instrument. There are two types of negotiable instruments, a promise to pay or an order. Now, if you're going to consider yourself a debtor, then you remain in the realm of promise to pay, and you do those kind of instruments. But those can only, and technically should only be done by corporate entities. Like I said, they cannot have assets.
Fascinating, because anybody who may deny this, which I don't think they will, because very few people have the capacity to actually understand a lot of this stuff. In UCC Article 3, Section 102, it's talking about all of UCC Article 3, which is only about negotiable instruments. It literally says this article applies to negotiable instruments. It does not apply to money. This is not a conspiracy theory, bro. So I've already shown you what a bill of exchange or bill looks like, but you get them in the mail and you hate them. So you know what those look like, your utility bills. Those are all bills of exchange. They're all negotiable instruments, just like these bad boys. And I'm going to teach you what that means. This is a promissory note. All mortgages, all bank notes, whenever you sign for a loan for a car, a loan for a business loan, it's a promissory note. So this note, the actual physical piece of paper that you're going to get and sign, this note basically is a negotiable instrument. Now you ask yourself, what does it need to be in order to be a negotiable instrument? Well, it has to be either an unconditional promise to pay, which is a promissory note, or order to pay, which is a bill of exchange. It has to be signed and it has to be written. Those are the three things it has to have in order to be considered a negotiable instrument. Everyone believes that when you're getting a loan, the bank gives you other people's money that's already in the bank at interest. But 12 United States Code Section 83 says that general prohibition, no national bank shall make any loan or discount on the security or shares of its own capital stock.
So when you think they're loaning you money, as in the form of Federal Reserve notes, so you can pay off the loan or pay the owner, that's not money, folks. You're not making payments. You're still making a promise to pay, and therefore you haven't paid. And I'm telling you once again, the only way you can pay is by directing the credits. Learn this stuff. And you do that in the contracting by letting them know you know the routing, and you're doing so and giving them the directive as a benefactor, not a party to the contract.
So how does the bank give you money? So the way the bank gives you money comes from the Federal Reserve Act, Section 16, Part 2. It's called note issues, but it's also found in the United States Code at Article 12, United States Code, Section 412. So the way it works is they tell you right here, you can make an application. Such application shall be accompanied with a tender, meaning giving somebody something.
Tender, to give. And if you're the one that's giving, you are the grantor.
Or offering somebody something to the Federal Reserve agent of collateral, an amount equal to the sum of the Federal Reserve notes that's applied for and issued, blah, 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 blah. So it's saying if you want to apply for notes, you need to give us some sort of something in exchange, right? The collateral security thus offered, meaning what you're going to give in exchange for the Federal Reserve notes, shall be notes, drafts, bills of exchange, acceptances, blah, 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 and other things, right? So what they're doing is they're taking, you're endorsing, which means releasing, which we're going to get into in a second, which is the most important part of all this. Your signature is where all the power is.
And he said endorse, and that's one of the things we're going to go over, as well as the endorse. See, when I did a video here last week about endorsing, the definition of endorse, E-N-D-O-R-S-E, is to make an amendment to an insurance policy, When you endorse, you recognize it as a contract, you remove your liability, and therefore it doesn't require insurance on your side, and you release the credits. Pay attention.
Once you sign it, what are the three things it has to have? Unconditional promise or order, unconditional promise to pay or order to pay, written and signed. That third part is when they slide the mortgage documents across the table and they say, sign here, sir. You are the one who's about ready to take that third one and bring that into existence. So the collateral security that they're going to give the Federal Reserve in exchange for the Federal Reserve notes when they write that application for notes is the negotiable instruments that you just created with your signature. The
And that is a security instrument now.
promises to pay or the bills of exchange, the orders to pay. You can actually, the way in which you sign things is where all the magic happens. And we're going to start to get into that right now. It's called endorsements. There's two different ways to spell it though. It's a lot more than what people think. So we're going to get into it now. So when you get into negotiable,
and I did do a video several years back on endorsement and endorsement. And what happens is when you endorse somebody, you're giving them credit. Say you're going to vote for Trump, that's an endorsement. You're giving him your credit that you have faith that he can do what you want him to do. That's endorse. When you endorse, that's a signature. Now they've conflated that an endorsement, E-N-D-O-R-S, is your signature, and that's not so. That's a different term. Again, I urge you people to get a concise English handbook, a dictionary, and a thesaurus. Start looking this shit up and then get into etymology and see where the origins are all at. Because you've been completely indoctrinated through propaganda of a public education system that doesn't want you to know this stuff, because that's the only way that they can profit off of your loss, is if you lose.
instruments and the creation of negotiable instruments, in my opinion, the most important part of all is the way that you sign. Now, the word sign and the word endorse, when it comes to a financial instrument, mean the same thing. You can actually take this word endorsement, I-N-D-O-R-S-E-M-N-T, which is how they spell it in UCC3, which we're going to cover. You can take that word and replace the word signature in your mind with the word endorsement, and your life will change forever. And the reason why.
What he's telling you, greetings, John. What he's telling you is that anytime somebody asks you for a signature, it's a negotiable instrument. How you doing tonight, John?
Doing great, Keith. And that
Good,
also means
good.
it means it's transferable. Is that right?
Correct. Correct. And this is what the bank takes when you sign up for an account at a bank. And what you're actually doing is you are making a transfer at that time of your rights, titles, and interest in the property. And that property is the document you signed. They're taking over your signature. That's what makes it your document. Pay attention at the end here. He's going to show you what they do because you don't qualify that signature. They qualify it.
Is what I'm going to tell you right now. So what everyone is doing on the whole planet all the time with these negotiable instruments, when they sign them, they're doing what's called a blank endorsement. If an endorsement is made by the holder of an instrument and it is not special endorsed, right? So what exactly is a blank endorsement? A blank endorsement means that it's payable to bearer, payable to whoever has it. It does not state a payee. It doesn't say who it's supposed to be paid for. It's a blank check. When you just sign and you don't say who the pro.
Remember the definition of coupon under 7 USC, what was it, 2012? Coupon. Yeah, it includes a check. Checks are coupons. Guess what? That bill that's got a coupon on the bottom, that's a check. It's the same damn thing. It's a negotiable instrument. And if you learn how to qualify that signature, I guarantee you, like you saw in my video earlier, I qualified the signature on the sales agreement from the local hospital's ER, where everybody else seems to placate I'm taking advantage of welfare. No, the credits are already in the system from the sweat equity labor that I produced already and paid into the Social Security and FICA. Those are insurance credits. That's what contracting is about. Again, it's about the insurance. And if I've already got the insurance credits established, then all I have to do is use them. I don't have to use welfare. I don't have to go get food stamps. I don't have to be on low income for a local public health clinic. I use the direct routing of what I know to be true and factual from experience.
Proceeds of this swap, the security swap, is supposed to go to, and you don't write the specifics in the endorsement. It does not state a payee. It's payable to whoever wants it. And the financial institutions take it as a gift. They're like, basically, the way they look at it is you just abandoned that security. Now, what they do is they put a special endorsement on it. They claim the security, and then they go to the Federal Reserve window and write an application for notes with the security that they just very cleverly had you donate. Oh, no, we didn't steal it. You just kind of donated it to us. Then they get the money from that, and then they loan you your own money back at interest. Now, I had my people go out and do some digging, get hold of some of their mortgage loans and stuff like that. We started taking a look, and we started finding.
I hope everybody can see this here. Correct, Kevin. You're authorizing a settlement. It's already settled. What is done is what ought be done. So if the credits are already there in that all uppercase name, and all you got to do is give the directive, then you say right on it, pay to the order of without recourse, and then the all caps name, by, and then your signature, and then benefactor below it. I don't know how many times I'm going to have to tell people this, but this is exactly what the code says. This is exactly what they've been doing. This is exactly what I saw them doing on the court documents, and I don't know how many other places. Look at your damn prescriptions. They're using a firm name.
Finding these endorsements on the thing. These are special endorsements. Pay to the order of without recourse. It's got the name. So they're putting on here.
And I want everybody to notice this is a ink stamp. It's a goddamn stamp. It fits the requirement. You got to think about this stuff.
Where the proceeds of this negotiable instrument are supposed to go to. It's just like a check. Pay to the order of on a check. Where are these funds going? They're claiming the value of this thing and getting it ready to swap it with the Federal Reserve. Look, pay to the order of, and then it has the name on there, by, and that's when they sign it right here. So this is a very specific thing. What is without recourse? We need to cover. So in financial transactions, the word without recourse disclaim any liability to the subsequent holder of a financial instrument.
So again, when I got that sales agreement and I put without recourse, pay to the order of, without recourse, Keith Little in all uppercase, by Keith Little, and signed it in that name and put benefactor, it was disclaiming any liability. Do you understand this? Now notice the ENDORSING. So when we look at this, we're gonna show you what endorsing says according to the UCC as opposed to the USC.
So they're just saying like, hey, if this doesn't work or you don't cash this or this something happened to this, you can't come back and get. Here's another example that we found. I'm going to show you one more after this. And here's the last example. I'm running out of time now, so I'm going to explain this to you. So you can do this yourself on your bills of exchange and your promissory notes. You can write without recourse, pay to the order of your name in all capital letters, by, sign there, and then below there, put your name. And you're saying, guys, I'm giving you this instrument, but I'm not donating it to you. You're allowed to go to the Federal Reserve window, bring back those funds, put those funds on my account, and it zeroes out the whole account, and you can give them the interest as a payment to do the swap for you. A lot of
There's that word again, swap. Are you getting it? And I want to point out now, folks, that when we're looking at those Federal Reserve notes as promissory notes, and you can literally put pay to the order of without recourse and your name and everything, look at that number on that fucking Federal Reserve note. That's the number on the back of somebody's Social Security card. That's how they put that money into circulation. And you redeem the money by that process, thereby taking it out of circulation. At least that's the way I interpret it. And this is the key to it all. The signature must be qualified.
places won't do it. You have to litigate to get this done. But I wanted to show you guys this in less than 10 minutes. I'm running out of time. A lot of information on my website. It's all totally free. Everyone should be doing this. It's awesome.
Yes.
Hello there.
So once again, and the link is I'm going to post a link down there for everybody again, for anybody that might have missed it. It is Williams, comma, Brandon, hyphen, Joe, period. Law made fun and simple. So what do you think, John?
Well, I don't think it's just money of exchange, the FRNs, as we were all told in the last 10 to 20 years. I mean, a lot of people thought it was. I see it as more of like a partial money of credit, in the sense that there's numbers on it, you know? So,
Right.
You know, it's another patriot myth that it's just worthless stuff going around. It has backing, it has value, it has energy expressed very uniquely, but it still, to me, has substance.
Absolutely. Absolutely. I'll show you something else that has substance. I don't know if I've got the actual letter with it here. I hope I do. There we go. Let me take my screen share off, or my screen settings off. Because this is something I spoke about before on the other end of a contract that has already been done and signed, and then they start billing you and you want to correct the bill. So my companion has health problems and goes to see several different medical associates in the area. And they had been sending her all kinds. This is from, there's dates on here from 97. Clear back in 97. For co-payments and stuff that they said that she was supposed to be making. Somehow they got missed. And they're not any of them really anything big. Let me, none of them are really anything big, as you can see on this balance due side here. But there's a bunch of them. So there's one page. There's 2 pages. There's 3 pages. There's 4 pages. There's 5 pages. There's 6 pages. And there's a couple more on a 7th page.
Wow.
So they were threatening to cut off her services, of which she's the beneficiary. Imagine that. The trustees threatening the beneficiary with detriment. So I wrote him a nice little letter. I'm going to read it to you. Let me show you. It's on my own little letterhead, my own little sigil design. You'll notice it's got some special numbers up here This one here is the original security number from my site, stating my living testimony of the living will of the living trust. From the Bureau of Chaplain Keith Orland Little, FBU, under his immutable counsel, full armor of God. I have no problem shoving that in these people's faces when they're doctors that take a Hippocratic oath to Apollo and the Greek gods. Blasphemous motherfuckers. Excuse my language. So we continue on, and it's got our reference Joyce A. Schmidt, all uppercase, and then it's got an account number as an index, and then a special note that I put on it, annex to last/firm, known as SCHM. How do I know this? All of the prescriptions, like I said, say so. And then the obligor number, which is her social security number without dashes. And then the ABA routing number on the back of her social security card. And then client is Joyce, all lowercase, semicolon, the beneficiary of all personal names derived therefrom. To whom these gifts present. Recently, Joyce received a bill which was requested for order of payment to clean all the accounts. We are transmitting copies of the bill that we received from Cedar Valley Medical Specialists, for which we accept as a true bill for the value stated in the instrument. We are transmitting, as it is patent in the instrument, there has been no value stated. Such commercial presentment is sufficient on its face for the value accepted. If Cedar Valley Medical Specialists find that there is a controversy, please be sure to contact the Board of Contract Appeals through the local postmaster and register a docket case number and provide proper diplomatic notice of service in all future transits of communications, whether they be literal, verbal, oral, or telecommunications. Contracts require privity first and foremost, which is arbitrary. If your records indicate that the account is out of balance, then it is yourself that has a duty to research and to assist us as co-trustees in good faith of personage to clean the accounts. This is the law of contract, and any disputes are to be resolved in arbitration according to the privy of contract. And then I'm going to
Well, put that in your pipe and smoke it.
absolutely learn how to contract, learn how contracts operate, and you can state them right back to them. So the next thing I put, never mind the note there, I'm just trying to cover up some private details, but look at the known parties. It's a grantor thrift trust, and its name is Joyce A. Schmidt. The obligor, like I said, is the social security number without dashes. The debtor is Joyce. Equity imputes an obligation or an intent to fulfill an obligation. That is the debt. And the debt is merely the obligation to correct the record. And you'll notice that is G-O-D. You guys know anything about subliminal messaging? I guarantee you they will see God in this document. How they think of God, I don't give a rat's ass, because the wicked flee and none pursue. Guess what? You can look up that epoch number, the annex number, and find out when this was written. And we'll do that here in a minute. But then I finish up. Owe no man anything but to love one another, for he that loveth another hath fulfilled the law. The only thing Joyce owes is to love, and that is a debt to all creatures. Absolute providence of his grace. And he that sat upon the throne said, Behold, I make all things new. And he said unto me, Write, for these words are true and faithful. So let's look up that epoch number. See how long ago this was written. And all we do is go to an epoch counter. In the meantime, while I'm looking this up, well, what do you got on it? Are true and faithful. So let's look up that epoch number. See how long ago this was written. And all we do is go to an epoch counter. In the meantime, while I'm looking this up, well, what do you got on? What's on your mind, John? You got anything?
Well, another thing I found is that I was hearing a lot about how they create money out of thin air. It's actually our activity that produces the notes. And then the banks, what they're doing is they're trading it to the treasury.
So let's look up that epoch number. See how long ago this was written. And all we do is go to an epoch counter. In the meantime, while I'm looking this up, well, what do you got on? What's on your mind, John? You got anything?
Well, another thing I found is that I was hearing a lot about how they create money out of thin air. It's actually our activity that produces the notes. And then the banks, what they're doing is they're trading it to the treasury for bookkeeping credits.
Correct.
So another patriot lie is that they're just doing this out of thin air. It's our activity, our energy.
Okay.
On the front side, anyway. You know.
Yeah, that's that sweat equity I was telling you about. It's our sweat labor, the labor that we've sweated throughout our life. Okay, it says 1618259150, and it says it was Monday, April 12th, 2021. So here we are. We're going on almost 3 years now. 3 years now, and she's still getting services. So tell me your words aren't powerful if you know how to use them. There was no dispute in court. I never got another word back from them. It was one fucking letter requesting a true bill. They sent me what they sent me. I sent them this letter. It's been 3 fucking years. Don't tell me that the wicked shall flee and none follow if you know how to make them. This is getting ridiculous, people. This is getting ridiculous. So let's start taking a look at some of these other things to get a little bit more clear on the definitions the man was talking about in the video there. Let's see. First one we're going to look at is Black's Law of Fourth. Just so you can see, it is the exact same one he read. In usual and ordinary acceptation, it means gold, silver, or paper money used as circulating medium of exchange, and does not embrace notes, bonds, evidence of debt, or other personal real estate. This is Lane versus Riley. Drop that case law in the chat so everybody can look that up. And I forgot to change my screen. There we go. Law fourth. Money in usual and ordinary acceptation it means gold, silver, or paper money used as a circulating medium of exchange and does not embrace notes, bonds, evidence of debt, or other personal or real estate. The next one we're going to look at is at 31 or 3 UCC 3-104 negotiable instrument. Says except as provided in this subsection or in subsection C and D, a negotiable instrument means unconditional promise to pay or order to pay a fixed amount of money. It has to be a fixed amount of money. And one of the things I want to point out here in this bill stuff, notice there's no plus signs. This is what I'm talking about, folks. How are you going to determine this? You can't put this equation in front of a mathematician and have them come up with a value in dollars, because there's not a dollar sign on here. There's not one mention of a dollar on here. So tell me how anybody would owe any kind of dollars if they don't transfer and convey dollars. The mathematical equation that equals zero. And it says, with or without interest or charges described in the promise or order, if it is payable to a bearer or to order at the time it is issued, or first comes into possession of a holder, or first comes into possession of a holder. So if I go to the doctor down at the local hospital, the emergency room, and they give me a sales agreement, that is a possession of a holder. It was not payable to order or payable to order, to bearer, or to order at the time it is issued, but it came into possession of a holder without such conditions. So the possession, the holder of the instrument now has the ability through rights of contract to put his conditions on there. Those conditions are merely a directive. Is payable on demand or at a definite time, and does not state any other undertaking. Remember, you are acting as an undertaker, like I said. You think I'm playing games? No, it's the words, and they're playing games with your mind with them. Understand what they're using here. Or instruction by the person promising or ordering payment to do any act in addition to the payment of money. But the promise or order may contain an undertaking or power to give, maintain, or protect collateral to secure payment, an authorization or power to the holder to confess judgment or realize on or dispose of collateral. That's the Social Security card. You're disposing the collateral because they gave the authority to do so, but it's your goddamn collateral. A waiver of the benefit of any law intended for the advantage or protection of an obligor. So you see, in my letter of acceptance of value, I waive the benefit of any law. It's arbitration in privacy, not in a court of law. The terms were already set. Instrument means a negotiable instrument. An order that meets all of the requirements of subsection A except paragraph 1. So when it comes into your possession as a holder, there's an exception, and now you can complete it yourself. Again, they're consulting you. Give them what they're looking for. Know how to make sure it's beneficial to you. Except paragraph 1 and otherwise falls within the definition of check in subsection F is a negotiable instrument and a check. Checks are guaranteed, folks. So as long as you fill it out and sign it appropriately, the appropriations will be made directly. A promise or order other than a check is not an instrument if, at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed, to the effect that the promise or order is not negotiable or is not an instrument governed under this article or governed by this article, excuse me. An instrument is a note if it is a promise. Thus, an instrument is a promise if it is a note, and is a draft if it is an order, and is an order if it is a draft. So when they give you a form that has blanks on it, and they expect you to draft or draw with your special drawing rights, then you get to draft on it your terms. You get to draw on it your terms. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either. So if you draft and don't put the proper signature or the proper data elements on it, and then hand it back, the holder of the instrument is entitled to enforce it. So if you don't place that on there, they can turn around and treat it as a draft and draft their information on it after you sign it, just like the gentleman showed us. Does that make sense, John? Do you see how that happens?
Yeah, I always thought the birth certificate was like a certificate of possessory interest, and the social card is more like beneficial interest. But what good is that if we're not fulfilling our role?
Right, and that's the problem. Yeah, you hit it spot on. That so SS5 is an official possession, and that's of an estate that they created based on a probate, because when you were born, you couldn't put your living will out. So at 18, when you became age of majority and you could put your living will out, no one taught you how to do so or what the effect was. Therefore, you didn't, and instead, you signed an SS5. And that's when you're supposed to come forth at age of majority and express your living will in the living word of the living God that you have a living trust with. You know how to move yourself. You don't need somebody else to look at a piece of paper and say, well, I think we need to put you over here. You're not the asset. You're not the collateral. So let's take a look at the next one, because he missed something in this bill of exchange I want to point out. And again, this is Bill of Exchange Act 1882. Same thing he was looking at. And he was showing about the bill means bill of exchange, and a note means promissory note. bankrupt includes any person whose estate is vested in a trustee or assignee under the law for the time being in force relating to bankruptcy. So when you sit there and say you don't have credits after you've been working all your life, you're considering yourself the debtor. You're saying that you're bankrupt. You've got somebody else that's been administrating that estate since you were 18, and that's the claim. It is disclosure. They are telling you. So we have to think about this stuff, folks. That burial trust that's established when you're born. And I didn't show that, did I? Let me show that. Bankrupt includes any person whose estate, and that's a person whose estate is vested, that's the investment, the investigation, in a trustee, that's the state, or assignee, that's the person. The Social Security number was assigned to the person under law for the time being in force relating to bankruptcy, because you again haven't come forth and claimed those credits. They're there. There's just been no claim on them, so it still sets as if though there's a decedent estate that had no will and is bankrupt.
There's no will, there's no way.
Which one or two? Subject matter. This article applies to negotiable instruments. It does not apply to money, to payment orders governed by Article 4A, or to securities governed by Article 8. And I said Article 9 earlier, and it should be Article 8 and 9. If there is conflict between this article and Article 4 or 9, Articles 4 and 9 govern. Why is 9 governing? Because that's the one that names the debtor and the location of the debtor. Again, coinciding with obligations and other securities of the United States under 18 U.S.C. 8 for special maritime territorial transactions, which are contracts under 18 U.S.C. 7, and those contracts are government contracts known as United States vessels, the SS-5, the enumeration at birth. Those are all government instrumentalities. They are negotiable. Regulations of the Board of Governors of the Federal Reserve System and operating circulars. Remember the operating circular number 1 we went over last week? Of the Federal Reserve banks supersede any inconsistent provision of this article to the extent of the inconsistency. This is the 12 U.S. Code 83 that he was talking about, loans by bank on its own stock. Federal Reserve notes are stocks of the Federal Reserve. They cannot make loans on Federal Reserve notes. Guess what? That means they can't give loans on the value of Federal Reserve notes. This is the problem with the reserve currency as opposed to the national currency. It's fractional. This is the 12 U.S. Code 83 that he was talking about, loans by bank on its own stock. Federal Reserve notes are stocks of the Federal Reserve. They cannot make loans on Federal Reserve notes. Guess what? That means they can't give loans on the value of Federal Reserve notes. This is the problem with the reserve currency as opposed to the national currency. It's fractional. You're not getting full value. You are partaking in the undertaking of a smaller fractional rate. Consideration, the side rate with side rate. It's not the full rate. You're not being fully compensated. Again, it's all done through the words, folks. For purposes of this section, a national bank shall not be deemed to be making a loan or discount on the security of the shares of its own capital stock if it acquires the stock to prevent loss upon a debt previously contracted for in good faith. Every one of those contracts are supposed to be contracted for in good faith. So any contract that turns around and demands that you pay with Federal Reserve notes is a false contract. Again, this is just my interpretation, folks. When it comes to the application for notes, collateral required. Any Federal Reserve note or Reserve Bank may make application to the local Federal Reserve agent for such amount of the Federal Reserve notes, hereinbefore provided for as it may require. This is 12 U.S.C. 412. Let's take a look at 12 U.S.C. 411 real quick before we get too much farther. Because under 12 U.S.C. 411, it says Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to the Federal Reserve banks through the Federal Reserve agents as hereinafter set forth, and for no other purposes are authorized. The said notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks, and for all taxes, customs, and other public dues. Taxes are public dues, not private. That's why when you pay taxes as a private man, it is a volunteer action. They shall be redeemed in lawful money on demand. When you order somebody to do something, do you demand them to do it? And if you put your demand in the document and you signed on it, is there lawful money on demand at the Treasury Department of the United States in the city of Washington, D.C., not the state, the city. It doesn't have statehood, and that's where the United States is located as the debtor under UCC 1-307, subsection H. Location of debtor. The United States is located in Washington, D.C. You agree with that, John? The United States has no sovereignty, do they?
No, but they try to get full jurisdictional control in Puerto Rico and Guam.
Yeah, absolutely. That's those offshore ships. Yep. Absolutely. And remember, that's territorial. Those are territories. That's where they get to play their contract games. Let's take a look at the next one. No, we got to go back to 412 yet. Such application shall be accompanied with a tender. That's that collateral. They got to give them a collateral. That collateral is that document you signed but didn't qualify it, so they did. So now a Federal Reserve agent was able to give them collateral for money in the form of credit. It's equivalent. Not Federal Reserve notes. Federal Reserve notes are not money. So they received money or its equivalent, which is credit. The local Federal Reserve agent of collateral in amount equal to the sum of the Federal Reserve notes, thus applied for and issued pursuant to such application. So they issued Federal Reserve notes. When you qualify it under that deposit to a financial institution where they're supposed to be obligated on giving credits, you have to make that directive. You have to give them that directive. Again, like that sales agreement said, customer agrees to make payment for third party so long as it's understood that credit is given to the customer's account. Not quite in those terms, but that's the basics of it. You're acknowledging that you're paying for the customer as a third party. And therefore, you know that the customer's account at the Social Security Administration holds the credit, and you're going to direct the transfer from there to the hospital via the routing of the numbers. The collateral security, that's that document signed, thus offered shall be notes, drafts, bills of exchange, or acceptances because they accepted your offer because you didn't qualify the signature, so then they got to draft theirs on it. Now it becomes their collateral. Acquired under section 92 of this title, or bills of exchange endorsed. There's that endorsed again and not endorsed. This is in the federal code. By a member bank of any Federal Reserve district and purchased under, let me read that one more time, purchased under the provisions of section 348A and 353 to 359 of this title, or bankers' acceptances, agent acceptances, banker acceptances. What about your acceptance? When are you going to learn how to accept it and qualify it? Purchased under the provisions of said sections 348A and 353 to 359 of this title, or gold certificates, or special drawing rights certificates. You're the one with the special drawing right, or any obligations which you're the one with the certificate and you just haven't drawn your statement of intent to give a directive to order the payments. Or any obligations which are direct obligations, direct of or are fully guaranteed as to principal and interest by the United States. This is why I say you have to put it in the interest of the United States, for the account of the United States, for full acquittance and discharge when it comes to correcting the estate. The United States or any agency thereof, or assets that Federal Reserve banks may purchase or hold under sections 348A and 353 to 359. Or any other asset of the Federal Reserve Bank. They don't have assets. They can't have assets. In no event shall such collateral security be less than the amount of Federal Reserve notes applied for. Read between the lines. In no event shall such collateral security be less than, therefore they're not saying it can't be more than, and they are not saying that they must be equal to. Therefore, it can be more than. It can be more than. The Federal Reserve agent shall each day notify the Board of Governors of the Federal Reserve System of all issues and withdrawals of Federal Reserve notes to and by Federal Reserve Bank to which he is accredited. Why is it accredited and not credited? You're supposed to tell me I'm not seeing the screen. My apologies. I'm not the best at this, folks. But the said Board of Governors of the Federal Reserve System may at any time call upon, this is a put call, a Federal Reserve Bank for additional security to protect the Federal Reserve notes issued to it. They need to collect up more collateral, because when they get $1,000 deposit, they deposit 1/10, a fraction of the real value of the deposit. That check it doesn't say Federal Reserve notes. It says dollars. That's presumed to be US dollars. So that gets deposited in an account. You get Federal Reserve notes. Check it out. When you cash that check, they're giving you Federal Reserve notes, and you can cash the whole check or just put the check in there and only pull out a portion of it. But on the other side, they're accessing that US dollar, which is more than what was deposited in Federal Reserve notes, because you didn't qualify it and get the US dollar portion of the real value of the deposit. That check it doesn't say Federal Reserve notes. It says dollars. That's presumed to be US dollars. So that gets deposited in an account. You get Federal Reserve notes. Check it out. When you cash that check, they're giving you Federal Reserve notes, and you can cash the whole check or just put the check in there and only pull out a portion of it. But on the other side, they're accessing that US dollar, which is more than what was deposited in Federal Reserve notes, because you didn't qualify it and get the US dollar portion. Shall not be required for Federal Reserve notes which are held in the vaults or otherwise held by or on behalf of the Federal Reserve banks. Give me a moment to drop this link down there for anybody that wants to jump on panel, just in case. Lenny with another one. They tried to dumb down the American people so they would never figure it out. If 1 in a million figures this out, the others won't believe them. Okay, so let's look at another one. Under the UCC, we've got the 3-109, payable to the bearer or to order. A promise or order to pay is payable to bearer if it states that it is payable to bearer or to the order of bearer, or otherwise indicates that the person in possession of the promise or order is entitled to payment. Okay, so if you get a blank, if you get a instrument that's endorsed in blank, has a blank endorsement, in other words, it's not qualified, you are now a holder of that instrument, and as holder of the instrument, you have the authority to enforce that instrument. You are entitled to payment. Does not state a payee, or states that it is payable to or to the order of cash, or otherwise indicates that it is not payable to an identified person. A promise or order that is not payable to bearer is payable to order if it is payable, 1, to the order of the identified person, or to an identified person or order. A promise or order that is payable to order is payable to the identifiable or identified person. Without recourse, paid to the order of Keith Orland Little, all uppercase. And of course, by, and then you sign it, and then benefactor. The payor is Keith Orland Little that signs it. The payee is the one it's payable to the order of. An instrument payable to bearer may become payable to an identified person if it is specially endorsed pursuant to section 3-205A. An instrument is payable to an identified person may become payable to bearer if it is endorsed in blank pursuant to section 3-205B. Special endorsement. Blank endorsement, anomalous endorsement. If an endorsement is made by the holder of an instrument, whether payable to an identified person or payable to bearer, and the endorsement identifies a person to whom it makes the instrument payable, it is a special endorsement payable to the order of, without recourse, the bearer. Works the same way. Now, when they pay it, give it back to you, guess what? Or, excuse me, when you give it back to them, guess what? You're doing the same thing as giving a blank endorsement. That's what your blank endorsement is. It's merely payable to the bearer, the one that's holding it, the one that has the right to enforce it, and all he's got to do is bear it before a teller and tender it. So be sure you understand what bearer means. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person. The principles stated in section 3-110 apply to special endorsement. Identification of person to whom instrument is payable. The person to whom an instrument is initially payable is determined by the intent of the person. Whether or not authorized, signing as, or in the name or on behalf of the issuer of the instrument. The instrument is payable to the person intended by the signer, even if that person is identified in the instrument by a name or other identification that is not that of the intended person. The person to whom an instrument is initially payable is determined by the intent of the person, whether authorized or not. So when they give you a document and say sign here, you have the ability to sign as, or in the name or behalf of, the issuer of the instrument. The government. They're all government instruments. And as a citizen of the United States or a resident of the United States, the all caps name is that person. It's a presumption. The instrument is payable to the person intended by the signer, even if that person is identified in the instrument by name or other identification that is not that of the intended person. If more than one person signs the name or behalf of the issuer of an instrument and all the signers do not intend the same person as payee, the instrument is payable to any person intended by one or more of the signers. This is why it's so important to fill out pay to the order of without recourse and the name, and then sign your name. It disallows anybody else from signing it and including other people as payees, as we saw the gentleman show at the beginning. Not intend the same person as payee, the instrument is payable to any person intended by one or more of the signers. This is why it's so important to fill out pay to the order of without recourse and the name, and then sign your name. It disallows anybody else from signing it and including other people as payees, as we saw the gentleman show at the beginning. Read a few comments here, see if there's anything here. There's AK Yogi again. Thanks for stopping in. You always have good comments. Not only content, most get angry when they are introduced to this or any subject they don't understand. Absolutely. And believe you me, people, I'm not trying to talk down to anybody. I'm trying to show you the plain language. You should be able to understand this stuff. So, and good evening, Kevin. You have yourself a good night. And we will continue to hope so. In the meantime, let's get back to it. Only got a couple more to go. If the signature of the issuer of an instrument is made by automated means, such as a check writing machine, the payee of the instrument is determined by intent of the person who supplied the name or identification of the payee, whether or not authorized to do so. So on that mortgage, if you don't qualify it, they turn around and by automated means, a stamp, boom, they stamp it, and you didn't know they did it, and you didn't authorize them to do so. But as holder of that instrument, according to contract law, that authorizes them itself. A person to whom an instrument is payable may be identified in any way, including by name, identifying number, office or account number. For the purpose of determining the holder of an instrument, the following rules apply. If an instrument is payable to an account, and the account is identified only by number, the instrument is payable to the person to whom the account is payable. You can give a number in lieu of a name and address, folks. So again, when you're involved in a contract, whether you're buying or selling anything, you can give a number, a widely recognized, commercially identifiable number in lieu of a name and address. You see how it correlates. 19 CFR 149.3 data elements under the custom code. It's customary that you protect yourself. It's customary that you learn, or excuse me, it's not customary, but you should be learning to route this stuff for the payable instruments to be paid by the person and not by you. When you do so, it exposes your name and address. You're doxing yourself, as they say here on the internet. If an instrument is payable to an account identified by number and by the name of a person, the instrument is payable to the named person, whether or not that person is the owner of the account identified by number. They own the account. You own the name. They translated your name in usufruct and subrogated the account to you. If an instrument is payable to a trust, an estate, or a person described as trustee or representative of trust or estate, the instrument is payable to the trustee, the representative, or a successor of either, whether or not the beneficiary or estate is also named. A person described as agent or similar representative of a named or identified person. The instrument is payable to the represented person, the representative, or a successor of the representative. Organization that is not a legal entity, the instrument is payable to representative of the members of the fund or organization. This is why we salvage it, resurrect it, and provide a merger with a new account that will fund the organization, and now you can write them out to your fund. The Keith Orland Little FBU. An office, or to a person described as holding an office, the instrument is payable to the named person, the incumbent of the office, or a successor to the incumbent. If an instrument is payable to two or more persons alternatively, it is payable to any of them and may be negotiated, discharged, or enforced by any or all of them in possession of the instrument. If an instrument is payable to two or more persons not alternatively, it is payable to all of them and may be negotiated, discharged, or enforced only by all of them. So if there's two signatures, it is payable to all of them and may be negotiated, discharged, or enforced only by all of them. So now you have the opportunity, if you understand this, payable to two or more persons not alternatively is another contract term if you want to agree to a shared payment. This would be in connecting your credit account with somebody else in order to make a endorsed signature with them, payable to the order of John Hopkins, without recourse, by Keith Little and John Hopkins. The next one, 3-302, holder in due course. Holder in due course means the holder of an instrument if the instrument, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity. The holder took the instrument, 1, for value, 2, in good faith, 3, without notice that the instrument is overdue or has been dishonored, or that there is an uncured default with respect to payment of another instrument issued as a part of the same series. Without notice that the instrument contains an unauthorized signature or has been altered. Without notice of any claim to the instrument described in section 3-306, which we'll read next. And without notice that any party has a defense or claim in recoupment. Does that look like a coupon by recoupment? Described in section 3-305. Notice of discharge of a party other than discharge in an insolvency proceeding, bankruptcy as we saw earlier, is not notice of a defense under subsection A. But discharge is effective against a person who became a holder in due course with notice of the discharge. Public filing or recording of a document does not of itself constitute notice of a defense. Public filing or recording of a document does not of itself constitute notice of a defense. Claim in recoupment or claim to an instrument. because it's a private issue. You're not supposed to be going to those courts and making those public filings and recordings. You're supposed to give them a letter of obligation, notice of intent to right themselves. Except to the extent of a transferor or predecessor in interest has rights as a holder in due course, a person does not acquire rights of a holder in due course of an instrument taken by legal process or by purchase in an execution, bankruptcy, or creditor sale or similar proceeding such as a mortgage eviction, auction, foreclosure, by purchase as part of a bulk transaction not in ordinary course of business of the transferor, or as the successor in interest to an estate or other organization. You're the successor of your mom and dad's estate that still sits in probate, still has credits sitting there, and you hold the principal interest in your own estate. So as next of kin to your mom and dad, you hold. You're the successor of your mom and dad's estate that still sits in probate, still has credits sitting there, and you hold the principal interest in your own estate. So as next of kin to your mom and dad, you hold a principal interest to their estate if you have brothers and sisters, and you can all go forth and make that claim together or singularly. If under section 3-30A1, the promise of performance that is the consideration with siderations for an instrument has been partially performed, the holder may assert rights as a holder in due course of the instrument only to the fraction of the amount payable under the instrument equal to the value of the partial performance divided by the value of the promised performance. What do you think so far, John?
Well, I guess the FRNs came a long way from their initial intent of being used by the board of directors for the Federal Reserve. I guess that was blown to hell.
Absolutely. And what about the signatures in relations to multiple signatures and how they take your signature and then qualify with their signature so they can get your credits at the drawing window for the issue of an advance of Federal Reserve notes? It's just amazing.
It's amazing how much we don't know about it. That's probably the most amazing, right, Keith?
Absolutely. And that's why I urge everybody, again, you got to get out there and do your research. I'm tired of seeing our younger generations walk out of high school thinking they have the education of a lifetime, when that's the farthest from truth. You've been indoctrinated. So let's continue on. If one, the person entitled to enforce an instrument has only a security interest in the instrument, and the person obliged to pay the instrument has a defense, claim in recoupment, or claim to the instrument that may be asserted against the person who granted the security, the person entitled to enforce the instrument may assert rights as a holder in due course only to an amount payable under the instrument, which, at the time of enforcement of the instrument, does not exceed the amount of the unpaid obligation secured. United States. If 1. The person entitled to enforce the instrument has only a security interest in the instrument. You don't have a security interest only in it, but the United States does, because they're not the principal in the security instrument itself. If the security instrument was issued or granted by a state, the state granted a security interest in it, but they're making a claim to that very security interest. The security interest is the obligation of the United States under obligations and other securities of the United States. Private communications with the United States. Equity. To be effective, notice must be received at a time and in a manner that gives a reasonable opportunity to act on it. This section is subject to any law limiting status as a holder in due course in a particular classes of actions. This section is subject to any law limiting status as a holder in due course. That's the enumeration at birth. It limits the status of holding in due course by conferring a nationality of United States citizen, saying that you're a trustee and you have to abide by the trustee laws and do as the law says. Again, correct it. You're the benefactor in private. And it's supposed to be a private thing, not a matter of public filing or records anywhere. Not just in the courts, but the Social Security Administration. That's an interest in the National Archives for its statistical use. That's a public filing saying you're subject to the commercial venue as a federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board. And it's all a false presumption. So let's look at that next one, the 3-306, a very short one, claims to an instrument. A person taking an instrument, such as a sales agreement, other than a person having rights of holder in due course, is subject to a claim of property or possessory right in the instrument or its proceeds. See, in fact, the people at the hospital, that treasurer, she has an obligation. She doesn't have a right to enforce the instrument in her own interest. That interest isn't there for her. Their interest is always bound by obligations and other securities of the United States. That's the United States interest that everybody's not putting out there as well, including a claim to rescind a negotiation and to recover the instrument or its proceeds. That's those instruments that I had them send me that true bill for my companion to recover the instrument or its proceeds. And if there's no value in it, then they can have their instrument back. A person having rights of a holder in due course takes free of the claim to the instrument. So yeah, they can have it back. They can have it back, free of the claim to the instrument. I don't have a claim to it. I accepted it for its value. It has zero value. Here you go. And sent it right back to him with my letter. Of course, I kept a copy. Kind of funny, I think. And with that, we come to the end of our stream. What do you got on your mind there, John?
I just can't believe that by not qualifying our signature or giving any directives, what they can get away with. Registering private data, fraudulent conveyance, even taking a tangible event, Keith, our birth, and turning it into intangible.
Yep. Absolutely. That's the problem. Like I said before, that 42 USC 1395X tells us about a spell of illness where on the first day they're given inpatient hospital treatment. And that's not a spell of illness, Mom. If you go to the hospital in labor, that's natural. You're not ill. It's not a disease. It's natural. And so when you do those kind of entrances into their public records and filings, you have to qualify your signature and let them know. Of course, it's relative to your estate that they're administrating still, because you still got that Social Security number until you correct your estate. So if you go to that hospital, you got to herald the coming of a legacy heir, an inheritor of you, your successor. So, if you got nothing else then, John, we're going to go ahead and close it out. And I'll be back again tomorrow with some more intriguing information. I think I'm